All right, we're doing CRW 2603 Learning Unit 3.
W2603/1. Learning Unit 3 Attempt, Conspiracy, and Incitement 5 Learning Outcomes. When you have worked through this learning unit, you should be able to demonstrate your understanding of the principles relating to anticipatory crimes by being able to explain whether certain conduct amounts to a punishable attempt to commit a specific crime, being able to explain in which circumstances an accused can be convicted of conspiracy or incitement. 3.1 Background. Until now we have dealt with completed crimes and have explained when a person would be guilty of a crime on account of his involvement in the commission of the crime before, during, or after its commission. In this learning unit, we will explain that a person may be guilty of an offense even though the crime that he wanted to commit was never completed. The instances that we are referring to are those where X attempts, tries, to commit a crime, but does not succeed in completing it, agrees, conspires, with another to commit a crime, does something to incites, another to commit a crime. Attempt, conspiracy, and incitement are often referred to as inchoate or anticipatory crimes, since they deal with forms of punishable conduct which anticipate or precede the actual completion of the crime. Why does the law punish not only the completed crime but also the above-mentioned anticipatory forms of conduct? One of the reasons is to be found in the preventive theory of punishment. The law seeks to prevent the commission of the completed crime. If these anticipatory forms of conduct were not punishable, the maintenance of law and order would suffer seriously, because the police would then be powerless to intervene when they happen to become aware of people preparing to commit a crime. Imagine the police hearing that a group of persons is preparing to rob a bank with the use of rearms. They know who the would-be robbers are, and they watch them get into their car and drive, armed, to the bank. If such anticipatory conduct were not punishable, one would have the ludicrous position that the police would have to wait till the completion of the crime, involving perhaps the shooting of innocent people, before they could catch the robbers. 243.2 ATTAMPT on attempt generally, see Javert, Chapter 4.3.2.1 Introduction. Attempts to commit common law crimes are punishable in terms of common law. Initially it was uncertain whether attempts to commit a statutory crime were also punishable, but this uncertainty has been removed by Section 15(1) of Act 27 of 1914, subsequently replaced by S18(1) of Act 17 of 1956, which clearly provides that an attempt to commit a statutory offense is also punishable. 3.2.2 Definition of rules relating to attempt. We begin by giving a definition of the rules relating to attempt. 11.1. A person is guilty of attempting to commit a crime if, intending to commit that crime, she unlawfully engages in conduct that is not merely preparatory but has reached at least the commencement of the execution of the intended crime. 12.2. A person is guilty of attempting to commit a crime, even though the commission of the crime is impossible, if it would have been possible in the factual circumstances, which she believes exist or will exist at the relevant time. If you nd these rules, somewhat difficult to comprehend at the RST reading, do not get discouraged. We shall explain them in the discussion which follows. 3.2.3 4 different types of attempt. There are 4 different types of attempt. They correspond to 4 different reasons why, despite having embarked upon the commission of a crime, X has not completed the crime. These 4 types of attempt are the following. 1. Completed attempt. In this type of situation, X does everything she can to commit the crime, but for some reason the crime is not completed. For example, where X rests at Y, but misses where X rests at Y and hits Y, but Y's life is fortunately saved by timeless medical intervention. This type of situation is implied in the RST paragraph of the definition of the rules relating to attempt given above. 2. Interrupted attempt. In this type of situation, X's actions have reached the stage when they are no longer merely preparatory but are, in EECT, acts of execution when they are interrupted, so that the crime cannot be completed. For example, X, intending to commit arson, pours petrol on a wooden oar, but is apprehended by a policeman just before he strikes a match. 25 CRW 2603/1X, a prisoner intending to escape from prison, breaks and bends the bars in the window of her cell, but is apprehended by a warder before she can succeed in pushing her body through the opening. This type of situation is implied in the RST paragraph of the definition of the rules relating to attempt given above. 3. Attempt to commit the impossible. In this type of situation it is impossible for X to commit or complete the crime, either because the means she uses cannot bring about the desired result, as where X, intending to murder Y, administers vinegar to her in the RM but mistaken belief that the vinegar will act as a poison and kill Y, or because it is impossible to commit the crime in respect of the particular object of his actions, as where X, intending to murder Y while she is asleep in bed, shoots Y through the head, but Y in fact died of a heart attack an hour earlier. This type of situation is implied in the second paragraph of the definition of the rules relating to attempt given above. 4. Voluntary withdrawal. In this type of situation, X's actions have already reached the stage when they qualify as acts of execution, when X, of his own accord, abandons his criminal plan of action, for example where, after putting poison into Y's porridge, but before giving it to Y, X has second thoughts and decides to throw the porridge away. This type of situation is implied in the RST paragraph of the definition of the rules relating to attempt given above. We shall now discuss these 4 forms of attempt. 3.2.4. Completed attempt. As a general rule, it may be assumed that if X has done everything he set out to do in order to commit the crime, but the crime is not completed, she is guilty of attempt. The following are examples where X rests at Y, but the bullet misses her, where X rests at Y and strikes Y, but Y's life is fortunately saved by timeless medical intervention. This type of attempt is implied in the RST paragraph of the definition of the rules relating to attempt given above. 2.2.2. In that rule, conduct that has reached the commencement of the execution stage is required. If, as is the case in this type of attempt, X has done everything she set out to do in order to commit the crime, there can be no doubt that her acts are acts of execution, as opposed to acts of preparation. The difference between acts of preparation and acts of execution will be explained in the discussion of the next type of attempt. 263.2.5 Interrupted attempt. 3.2.5.1 Introduction. The majority of reported cases on attempt deal with this form of attempt. Whereas there is, as a rule, no difficulty in holding X liable for attempt in situations of so-called completed attempt, described above, in cases of interrupted attempt it can often be difficult to decide whether X's conduct amounts to punishable attempt. Mere intention to commit a crime is not punishable. Nobody can be punished merely for her thoughts. A person can be liable only once she has committed an act, in other words, once her resolve to commit a crime has manifested itself in some outward conduct. However, it is not just any outward conduct which qualifies as a punishable attempt. If X intends to commit murder, she is not guilty of attempted murder the moment she buys the revolver, and if she intends to commit arson, she is not guilty of attempted arson the moment she buys a box of matches. On the other hand, it stands to reason that there does not have to be a completed crime before a person may be guilty of attempt. Somewhere between the RST outward manifestation of her intention and the completed crime, there is a boundary which X must cross before she is guilty of attempt. In cases of this nature one must, in fact, differentiate between 3 different stages. In the RST stage, X's conduct amounts to no more than mere acts of preparation. For example, intending to kill her enemy, Y, X merely buys a knife. If this act of preparation is the only act that can be proved against her, she cannot be convicted of any crime. In the second stage, her acts have proceeded so far that they no longer amount to mere acts of preparation but, in fact, qualify as acts of execution or consummation. For example, after searching for Y, she NDS him and charges at him with the knife in her hand, although a policeman prevents her from stabbing Y. In this case, X is guilty of attempted murder. In the third stage, X has completed her act and all the requirements for liability have been complied with. For example, she has stabbed and killed Y. In this case, she is guilty of murder, the completed crime. The distinction between the RST and the second stages is crucial in determining whether or not X has rendered herself guilty of attempt. Again, the distinction between the second and third stages is crucial in determining whether X has committed merely an attempt or whether she has committed the completed crime. 3.2.5.2 The rule applied in cases of interrupted attempt liability for attempt in this type of situation is determined by the courts with the aid of an objective criterion, namely by distinguishing between acts of preparation and acts of execution or consummation. 27 CRW 2603/1 If what X did amounted merely to preparation for a crime, there is no attempt. If, however, her acts were more than acts of preparation and were, in fact, acts of consummation, she is guilty of attempt. Although this test, namely to distinguish between acts of preparation and acts of consummation, may seem simple in theory, in practice it is often very difficult to apply. The reason for this is the vagueness of the concepts preparation and consummation. In applying this test, a court has to distinguish between the end of the beginning and the beginning of the end. Each factual situation is different, and the test as applied to one scenario may be no criterion in a different factual situation. In Katz 1959, 3, SA 408, c. 422, it was stated that a value judgment of a practical nature is to be brought to bear upon each scenario as it arises for consideration. 3.2.5.3 Examples of the application of the rule. The most important case in which the courts have enunciated this test, namely to differentiate between acts of preparation and acts of consummation, is Scobie 1945 AD 541. Here, X went to a shop in the early hours of the morning and poured petrol around and underneath the door so that the petrol owed into the shop. He placed a tin of inflammable material against the door, but his whole scheme was thwarted when, at that very moment, a policeman appeared. The appellate division confirmed his conviction of attempted arson and, in the judgment, authoritatively confirmed that the test to be applied in these cases was to distinguish between acts of preparation and acts of consummation. The following are some further examples of the application of the test. 1. Mere acts of preparation, i.e., acts in respect of which X cannot be convicted of attempt. X, intending to murder Y, merely prepares the poison which she means to use to poison Y later, when she is caught. X, intending to buy goods which she knows to be stolen goods, conduct which would render her guilty of the crime of possessing stolen goods, is merely inspecting the goods which the real burglar has stolen, when she is apprehended. Crowcombe 1949, 1, SA 377, A. 2. Acts of consummation, i.e., acts in respect of which X can be convicted of attempt. X, trying to rape Y, has, as yet, only assaulted her when he is apprehended. W 1976, 1, SA 1, A. X, trying to steal from A woman's handbag, has opened the handbag hoping that its contents will fall out when she is apprehended. 3.2.6 Attempt to commit the impossible. 3.2.6.1 The subjective approach. With this form of attempt, the person is unknowingly prevented from committing the completed crime because the means she uses cannot produce the intended result. 4.28 Example, where X attempts to poison Y with a harmless substance. Another example is where X rapes a woman while unaware of the fact that she is already dead. W. Supra. To determine whether a person is guilty of this form of attempt, a subjective criterion is used by focusing on the actual intention of the perpetrator. In Davies 1956, 3, SA 52, A, the court had to decide whether X was guilty of an attempt to commit the former crime of abortion if the foetus which he had caused to be aborted was already dead, although he had believed the foetus to be still alive. The crime of abortion could, in terms of its definition, be committed only in respect of a live foetus. The appellate division adopted the subjective test and held that X was guilty of attempted abortion. It further held that X would have been guilty of attempt even if the woman had not been pregnant, provided, of course, that X had believed that she was pregnant and had performed some act intending to bring about an abortion. It is immaterial whether the impossibility of achieving the desired end is attributable to the wrong means employed by X, or to the fact that the object in respect of which the act is committed is of such a nature that the crime can never be committed in respect of it. In cases of attempt to commit the impossible, the test according to this decision is therefore subjective and not objective. What the law seeks to punish in cases of this nature is not any harm which might have been caused by X's conduct, because such harm is non-existent, but X's evil state of mind which manifested itself in outward conduct which was not merely preparatory, but amounted to an act of execution. Note that the rule that, in order to be convicted of attempt, X's act must be an act of consummation, also applies to this form of attempt. Activity X, Y, and Z plan to rob a cash-in-transit vehicle. As the vehicle approaches, they start ring gunshots at the driver. Because the windows of the vehicle are bulletproof, the driver is not injured. X, Y, and Z are charged with attempted murder. Explain whether they may be convicted of this crime, even though it was impossible to injure the driver of the vehicle. 6 Feedback. The facts are similar to those in the case of Ngamu 2011. 1. SACR 166, SCA, where the court convicted the accused of attempted murder. The court explained that the conduct of the accused amounted to punishable attempt, even though it was impossible to injure the driver of the vehicle. 3.2.7 Voluntary withdrawal. It is generally accepted that there is no punishable attempt if X voluntarily abandons her criminal plan of action at a stage when her actions can only be described as preparations. In other words, before her conduct constitutes the commencement of the consummation. The question is simply whether a withdrawal after this stage, the commencement of the 29 CRW 2603/1 consummation stage, but before completion of the crime, constitutes a defense to a charge of attempt. The courts have answered this question negatively in Hlatwayo 1933 TPD 441. X was a servant who put caustic soda in her employer's porridge, intending to poison them. She noticed that the caustic soda discolored the porridge and so threw the mixture away. She was nevertheless convicted of attempted murder. The court held that her acts had already reached the stage of consummation and that her change of heart did not exclude her liability for attempt. 3.2.8 Intent. A person can be found guilty of attempt only if she had the intention to commit the particular crime towards which she strove. Negligent attempt is notion ally impossible. One cannot attempt, that is, intend, to be negligent. There is, therefore, no such thing as an attempt to commit culpable homicide. Antanza 1981, 4, SA 477, and, because the form of culpability required for culpable homicide is not intention, but negligence. 3.3 CONSPIRACY. You must study this crime as discussed in Joubert, Chapter 4.3.4 INCITEMENT. You must study this crime as discussed in Joubert, Chapter 4. Summary. Attempt. 1. There are 4 forms of attempt, namely completed attempt, interrupted attempt, attempt to commit the impossible, and voluntary withdrawal. 2. In cases of completed attempt, X has done everything she set out to do in order to commit the crime, but the crime is not completed, for example where X rests a gunshot at Y but misses. 3. In interrupted attempt, X's actions are interrupted so that the crime cannot be completed. In these cases, X is guilty, provided that his actions are no longer mere acts of preparation, but in fact constitute acts of consummation. 4. In cases of attempt to commit the impossible, it is impossible for X to complete the crime, because either the means she uses cannot bring about the desired result or the object in respect of which the act is committed is factually impossible to attain. 5. In Davies, Supra, it was held that a subjective approach towards attempts to commit the impossible should be followed, and that a person is guilty of attempted abortion if he aborts a dead foetus in circumstances in which he believes that it is still alive, even though an abortion can only be committed in respect of a live foetus. 30. 6. In cases of voluntary withdrawal, X, of his own accord, abandons her criminal plan of action. According to our courts, such withdrawal is no defense to a charge of attempt if it occurs after the commencement of the consummation. 7. Intention is always a requirement for a conviction of attempt to commit a crime. Conspiracy. 8. Conspiracy to commit a crime is punishable in terms of Section 18(2) of Act 17 of 1956. 9. The act of conspiracy consists in entering into an agreement to commit a crime. 10. The crime is completed the moment the parties have come to an agreement, and it is not necessary for the state to prove the commission of any further acts in execution of the conspiracy. 11. The intention requirement consists in the intention to conspire as well as in the intention to commit a crime or to further its commission. Incitement. 12. Incitement to commit a crime is punishable in terms of Section 18(2) of Act 17 of 1956. 13. X ought to be charged with, and convicted of, incitement only if there is no proof that the crime to which he incited another has indeed been committed. 14. A person may be convicted of incitement even though there is no proof that she had persuaded the incitee to commit the crime. 2. Test yourself. 1. Name the 4 forms of criminal attempt and explain why what each entails by giving an example of each. 8. 2. Give examples of an act of preparation and an act of consummation in the case of interrupted attempt. 2. 3. Discuss whether X can be convicted of attempted murder if she unlawfully rests 3 shots at Y sitting in a car with the intention to kill Y, but she, X, is unaware of the fact that the closed windows of the car are bulletproof and Y is not injured at all. 4. In which circumstances will voluntary withdrawal be a defense to a charge of attempt? Explain. 5. Discuss the requirements for a conviction of the crime of conspiracy. 6. X incites Y to become involved in drug dealing. Y, who is a police trap, agrees, but once she infiltrates the drug dealing network, she arrests X for incitement to commit the statutory offense of dealing in drugs. Can X be convicted of incitement even if she did not really persuade Y to commit a crime?